The Honorable Chief Justice and Justices of the Supreme Court of Ohio. The Honorable Supreme Court of Ohio is now in open session pursuant to adjournment.
Good morning. Good morning, ladies and gentlemen. We are here for our first case of 2020-511 in the matter of the application of Duke Energy, Ohio Incorporated for a certificate of environmental compatibility and public need for the C314V Central Corridor Pipeline Extension Project. And you will note that Justice Pat Fisher is not on our panel this morning. And sitting in for Justice Fisher is Judge Jennifer Hensel. And Judge Hensel is from the 9th District Court of Appeals. And Judge, we appreciate you visiting with us today.
Thank you.
All right, we're going to start with the appellant, and I see there's three attorneys arguing for the appellant, and we'll start with Mr. Pacheco.
May it please the court, Chief Justice O'Connor. Good morning. My name is Brian Pacheco, and I represent David Waltz, City Manager on behalf of Intervenor City of Blue Ash. I will be speaking for 7 minutes, and then Mr. Stevenson's Reddings Counsel will be speaking for 3 minutes. And then Mr. Here, Nobes Counsel, will be speaking for 3 minutes, and I would like to reserve 2 minutes for rebuttal. Thank you. This power siting board decision approving the high pressure distribution pipeline through Northeast Cincinnati's densely populated suburbs is governed by a specific statutorily mandated scheme in Revised Code Chapter 4906. The 8 specific statutory standards mean something. They require robust findings and determinations, and they must be the product of a detailed, vigorous, and public siting process. The Supreme Court must step in to ensure that the statutory mandates are met and to protect intervening communities like Blue Ash. Indeed, this case exemplifies that need for court intervention. Here in at least 3 ways, in violation of both the revised and the administrative codes, the board approved the pipeline route, 1, without even considering Blue Ash's most recent land use plan, which describes Summit Park, a regional destination park with 850,000 visitors per year. 2, without even knowing that the alternate route abutted Summit Park. So the board never vetted, nor considered, nor accounted for the obvious issues resulting from siting a pipeline next to a regional destination park. Finally, Duke never provided an estimate, under any sense of that word, of the increase in tax revenues as a result of the pipeline's placement. In fact, the board went so far as to conclude in paragraph 74 of its reconsideration decision that Duke was not required to explain the underlying basis of its tax revenue projections or to confirm its calculations. The process problems are articulated here not only by Duke, but also by the board. At page 32 of the board's brief, the board says that the time to challenge, that there are no more impacts after certification. And then on the same hand, the board says that the time to challenge such impacts occur at the adjudicatory hearing and cannot be challenged after the fact. Duke, on the other hand, is recognized in paragraphs 72 and 108 of the board's original decision, where the board specifically said that Duke responds that the questions raised by Blue Ash, and those dealt specifically, when you read those 2 paragraphs in context, about Summit Park and about potential risks associated with a high pressure pipeline in highly congested recreational area, traffic and construction concerns, quote, cannot be answered until a specific route is chosen. So what the process has now become is that the board articulates that at the time of the hearing, the intervening communities like Blue Ash, like the other 13 involved here that were through which this pipeline goes through, have to have all of the information at the time of that adjudicatory hearing to challenge and to vet whatever impacts occur for the pipeline. On the other hand, they then say, and then after that, there's no more time to challenge. On the other hand, Duke says, we can't even give you the information about the pipeline's impacts until a specific route is chosen. So there is no process. If that's the case, if that's the law, there is no process, there is no ability for the city of Blue Ash to, or any other interveners for that matter, to vet, to challenge, in the words of a recent Black Fork case, to provide the material information necessary to provide an informed challenge for intervening communities. The Middletown Coke case talks about how Monroe was not allowed the opportunity to test the proposition, that is, that the route selected was the proper route under the statutory standards. These are mandatory standards. They must be found before the pipeline is certificated, not after. And the board and Duke will surely say, well, this is a dynamic process. And they will cite the Buckeye Wind case for the notion that this is a dynamic process so that they can approve first and vet later and check later. But the problem with relying on Buckeye Wind is that Buckeye Wind was a plurality opinion. It was not the law of this court. It has never been the law of Ohio that it's a dynamic process. And the board continues to cite it in paragraphs 164 of its original opinion and paragraph 46 of its reconsideration decision. The board also cites that in its brief, and the Duke also cites it at pages 38 and 39 of its brief to say why they can provide this information after the fact. In addition, it's not a dynamic process in any sense of the word when Duke is able to provide information after the hearing to check the box for the power siting board to recognize the statutory factors. And in this particular case, after being alerted that Duke did not, in fact, consider Blue Ash's most recent comprehensive land use plan, its most current land use plan, which is required by the administrative code provision, that they never went back to look at that. And keep in mind that the staff report here that recommended the alternate route was issued in May of 2017. Duke then amended its application and submitted an amended application, submitted supplemental information. It had amended its application before. It submitted supplemental information a year later, and that didn't consider the route. So it's not a very dynamic process when the intervener's information, which is clearly correct as a matter of fact, Duke clearly did not consider the most comprehensive land use plan. The bottom line here is that that's not a dynamic process, and the dynamic process construct must be rejected by this court. It has never been the law of the land. It has never. I'm sorry.
When was Blue Ash's land use plan issued in 2016? And was it reasonable for Duke to have to amend what it was submitting to the board once it knew it had to use the alternate route to show the factors that you wanted to see before the hearing?
Yes, Your Honor. It was amended in early 2016, though the specific date was not in the record to answer your question, but it was amended in early 2016. The best that I can tell, and I see my time is almost up, so I will finish the answer to the question. But the best that we can tell is all Duke did was go on the website and pull up a comprehensive plan. Duke never had any consultation with local officials. In fact, that's the interesting point. In footnote 13, the board's of paragraph 75 of the original decision, the board specifically says that applicants, it's not Blue Ash's responsibility. That's the other thing. This is Duke's responsibility and the board's responsibility to find for the statutory factors. But that's not Blue Ash's responsibility. But the point was they never had any consultation with any public officials. Had they would have known that the comprehensive plan was changed back in early 2016. And I might add, by the way, the route selection supervisor, Dr. Nicholas, testified that had they known about Summit Park, they might have gone back to the drawing board. So it's a significant issue.
Thank you.
Thank you, Justice Bruner. Chief Justice, I see my time is up, so thank you.
Thank you. Mr. Stevenson?
Thank you, Your Honor. I want to concentrate my argument on two administrative code sections, the first being 4906-3-05, which requires pipeline applications to contain fully developed information on two routes, each of which must be a viable alternative on which the pipeline can be constructed. And the second is 4906-3-06, which indicates that incomplete applications are to be rejected. Both of these rules are mandatory and not discretionary. The rules are not there to protect utilities. In fact, they impose obligations on them. The beneficiaries of these rules are the communities and the residents that live along the proposed routes. The core purpose of requiring fully developed information on two routes is so that an educated choice may be made between them. Such a choice can only be made from fully developed information that necessarily results from an investigation. In this case, the board staff made its route citing decision on May 31st of 2017, choosing the alternate route. The decision was not informed as the application did not include fully developed information on the alternate route. We know that because in August, Duke told us when they moved to suspend the procedural schedule that they had not done a sufficient investigation on the alternate route. They said that their primary focus had been on the preferred route, where design was partially completed, soil borings, utility locations, and surveying was significantly completed. Duke indicated that it needed additional time to further investigate the alternate route. Rather than rejecting Duke's now incomplete application as required under the plain text of its own rules, the Power Siting Board allowed Duke to complete an after-the-fact investigation and supplement its deficient application with a wholesale substitution of a new investigation of the alternate route. This amendment was allowed without the filing of an application to amend and without a hearing. In both the original opinion and the opinion on rehearing, the Power Siting Board brushed aside Reading's concerns that it had not followed its own rules by requiring Duke to provide this fully developed information on two routes and failing to reject Duke's application when it did not do so. The board simply determined that Duke provided the required information as they went along during the course of the proceeding, and regardless of its own rules, the board had heard enough. If you wanted specific information on it, you can find, they refer to it as generally a general expectation in paragraph 122 of their original entry dated 11/29/19. The City of Reading submits that in failing to follow its own rules, the Power Siting Board acted in an arbitrary, capricious, and unlawful manner and asked this court to so find. And unless there are any questions, I don't have anything for it.
Mr. Stevenson, could you address prejudice, how they were prejudiced, how your client was prejudiced by the information being reviewed by staff late?
How Reading is prejudiced by it? They're opening up our streets and putting a pipeline in, for one thing. We have a number of objections.
But the specific prejudice, your point is that this information wasn't reviewed by staff until later on. So how did that prejudice you?
It's prejudice because the original choice was made without the information. Once that choice is made, it's not going to change. They become attached to that choice and it goes forward all the way through. Reading was not on the preferred route. It was on the alternate route. To our knowledge, they've never chosen the alternate route before this time.
But what is in the information that you're saying they didn't have that's harmful, it's prejudicial?
The information that they didn't have involved a Superfund site that was at the north end of the town that was in close proximity to the proposed pipeline. It wasn't on the exact same parcel, but it was on the adjoining parcel. The additional information that they didn't have was that the City of Reading owns a 14-acre site at the south end of town that the state of Ohio has put up about $3 million to provide for development, and the pipeline was drawn right through the middle of it. That's how we were prejudiced. That information was never communicated to them until after the fact.
Thank you.
Thank you. Thank you. We'll now hear from Mr. Here.
Thank you. May it please the court. My name is John Here, and I'm representing the neighbors opposed to the pipeline extension. And we've been using the acronym NOPE to refer to them. And my client agrees and joins with all of the able arguments that have been made by my co-counsel among the appellants. But I just want to focus this court's attention on one issue. This case presents an opportunity for this court to make a difference. This case shows how the Ohio Power Siting Board simply misinterprets its statutory duties under Ohio Revised Code 4906.10a. I want to step back for a second and ask you, what's at stake in this thing? It's Duke Energy's application for a certificate of public need. A certificate of public need. This public need is the very first criterion in 4906.10a. The board shall not grant, and that language is very strong, it shall not grant a certificate unless it finds and determines, and again, it has to find and determine, not Duke, finds and determines the basis of the need for the facility. That one word, need, from 4906.10A can be dispositive in this case. The record, and especially the post-hack rationalizations that are in the board's and Duke's briefs, demonstrate that every time we have asked them to explain what they found and determined to be the basis of the public need, the board countered with Duke's needs, their corporate needs. What was important to the corporate strategy for Duke? What gives them the most profits? Not the public need. They even rely on data from Kentucky's needs, that's different in 2020. They even say, this is extremely bold, they say in their brief, quote, nowhere in 4906.10A does it require that the board find the general public has a definite need for the facility. Wow. The board got it wrong.
Mr. Here,
Here, yes, I'm sorry.
do the conditions imposed as a result of the approval, I think there's 40 some conditions, do those in any way express the board's recognition of the public need? I mean, I'm looking at sort of the balancing factor too, of that you've got things that have, you've got old pipeline and tanks that have been there since the 1940s and the 1960s and don't know what shape they're in, and those are going through neighborhoods. And there's also the question of capacity, but the safety issue, I'm looking at that. I mean, is it implicit in what's been done that, and in the conditions that the board has looked at those needs in reaching its decision?
I don't think it's implicit. I don't think it's there, but as I said, they have the burden to show that they found and determined the basis of the need for the facility. And I don't think it's shown. I think every time that they try to demonstrate this basis of need, they're showing you what Duke's needs are, the corporate needs are. If you look at their response in their brief, all they focus on are the north and south balance, for instance, or the antiquated facilities that they need to update, or all of these have to do with the corporate need, not the public need. And that's where I want the court to focus, that word has a meaning. And it's it's the very first criterion listed in the statute and in the administrative code. And that is where I think that this court can be dispositive and make a real difference by focusing the Ohio Power Siting Board on the public need.
But aging gas pipelines have caused fires in places around the country that have been very deadly to neighborhoods. Isn't that tied up with the question of aging facilities and equipment? Isn't that tied up with the need?
It could be. I mean, I think that the problem is that they didn't really look at that. I mean, they looked at it very briefly, but again, I'm just trying to focus on what they have responded as what they found and determined to be the need for the facility. And every time we talk about the need for the facility, they talk about Duke's needs. They don't talk about the factors that you mentioned. And I think the court can change the future by finding that the 4906.10A requires the Ohio Power Siting Board to find and determine the basis of the public need for the facility before granting a certificate of public need. The court should reverse the board's order and entry on rehearing and remand for a real evaluation of the public's need.
Thank you. Thank you. For the appellee, I guess we're going to start with Mr. Beeler.
Chief Justice. May it please the court, I'm Steve Beeler, and I represent the Ohio Power Siting Board. I'd like to reserve 5 minutes of my time for counsel for Duke. Your honors, the board...
Counsel, what, you're going to reserve 5 minutes for Duke, did you say?
Correct, Your Honor.
Okay. Okay. Did you take into consideration, did the board take into consideration what Mr. here just mentioned, the public need? And if so, how?
Absolutely, Your Honor, and Justice Bruner hit the nail on the head. You know, this case is about Duke's obligation to furnish necessary and adequate service under Revised Code 4905.22. This case is about reliability. And for that reliability, this pipeline affects the public. It obviously affects the public. And that is considered. And in the 3 reasons that Duke cites, the retirement of outdated peaking facilities, the balance of its system, to not rely on one delivery point, and to allow for necessary upgrades. That's both the need for the company and the need for the public. There's an alignment of interests here. And the Loomis report in this case, which is a key piece of evidence, it basically supports all three, and especially the first peaking facilities requirement. These are facilities that are at the end of their useful life, and they may fail at any time. This pipeline is safe, and it's going to be built under stringent transmission line requirements. Throughout this 4-year process, appellants were provided with the necessary information and process. Following this process, the board properly considered and rejected each of appellant's claim based on facts in the record, and its order should be affirmed. The application was complete with fully developed information.
Mr. Bulis?
Yes.
So one of the problems that I think that the appellants have had was the access to information and maybe some of the transparency and just better communication. It's real clear that your technical staff was working closely with Duke as anyone would in that kind of a situation where it is highly technical. But it seems that they could not get information in a timely manner to meaningfully put their positions before the board. How do you address that?
Well, the answer is that the hearing process is the process where appellants, have opportunities to request information. They through discovery, they have opportunity to question staff witnesses, question Duke witnesses. Much of the information that appellants claim that are lacking here relate to the conditions and to the mitigating factors of the impacts of this case, which the mitigating factors are, that's what the conditions mitigate the impacts. So the impacts are decided at the hearing level. And then staff monitors those mitigating factors. Much of the information, contact info for safety officials, emergency response plans, conversations with responders is information that will be handled in the mitigation process.
So
Finally,
excuse me, did you negotiate any of those conditions with the appellants?
The appellants made arguments about conditions at the hearing, or at least interveners did, and the board did enhance the conditions from the staff report, and then they also added a few new conditions to deal with further work with affected communities, some additional consulting work to be done, in additional notice to communities.
But is there anything wrong with, while staff is actually working with the applicant, is there anything wrong with also conversing with people who are already expressing an interest through requests for information to sort of bring the parties together, or is that just Duke's responsibility to do that?
Staff does have, through its investigation, can speak with communities, but Duke does carry the weight in communicating with communities that are affected by this pipeline, and through all the public testimony, through all the application process, the amended application process, public hearings, evidentiary hearings, that was all provided to the best way possible, and the board noticed that.
Did you have any information from Duke that Duke had actually been in any kind of ongoing discussions with the neighborhoods and with the local governments?
Counsel for Duke may be able to handle that one a little bit better on what Duke spoke with, the communities about.
No, I'm asking if the board had the information.
The board did have the information it needed to complete, to begin its, basically the letter of completeness to.
No, I'm talking about, did the board have any information that Duke was conferring with the local communities and the residents there prior to the final hearing?
Yes, to some extent, and this is a large process with lots of information. Whether certain things are covered or not covered is something that it needs to be brought up at hearing, and was in this case and considered by the board. And also any allegation that there was just a check the box standard here from the board is just incorrect. The application and the amended application and the amended staff report and the wealth of public comments and public hearings and the evidentiary hearing process provided ample record for a basis of the commission or the board's decision.
Do your rules provide for amended applications?
Yes, they do. The revised code and the rules provide for amended applications.
Isn't that amendments to completed applications?
Yes, absolutely. So
That's not what was really here, was it? I mean,
well, here the letter of completeness did go out on the original application, but the staff chose the alternate route, and then Duke decided that
but weren't they required to have all their information on the alternate route?
Yes, and staff found that they did. And then beyond that, with the new information, there's no law that prohibits Duke from supplementing their information, which they did here.
But I think the rule says it's supplement a completed application, right?
Correct, but the board then treated that supplemental information as an amendment and properly, and then that basically started the process over. You have new public notices, amended staff report, new public hearing, additional discovery. So from that point, both routes, the preferred and the alternate, were surely fully developed. And a fully developed is a key word here. That's a discretionary term. The board found that the application was fully developed.
Did you consider the new Blue Ash comprehensive plan?
Your Honors, the Blue Ash plan came out. The newest one came out after the C2HM Hill study, the route selection study consultant. Duke was not required to redo the study at that point. And again, Blue Ash did not present any evidence of harm on this plan. At the time of the study, it was the most recent plan, and that was what was required.
I mean, had the new plan been done? I mean, I know it wasn't in effect, but had it been created at the time?
I don't know that, Your Honor, whether it was done. Early 2016 is what appellants said, and I'll take their word for it. Again, this pipeline will be safe. Duke has agreed to adhere to higher transmission safety guidelines, which means thicker pipe, less pressure, more shutoffs, buried at twice the depth, and enhanced testing. To conclude, Your Honors, this pipeline is necessary and will be safe. Duke provided complete information, and the board provided ample due process in analyzing and improving construction of this pipeline. The board should be affirmed. Thank you.
One last question. Did the board in its findings make any sort of weighed comparison on whether these enhanced standards in the new pipeline would be safer than what was in existence?
Yes. Well, the reliability factors and the fact that there's so much reliance on the Foster station and peaking reliance on these peaking facilities. That's a big thing, Your Honor. That's the Loomis report said that those could fail at any time, and that's when on very cold days when peaking facilities do their job. So yes, the board did do weighing on the evidence.
Thank you.
Thank you.
Thank you. We will have the remaining 5 minutes for Mr. Paragas.
Yes. Thank you, Your Honor. Good morning. My name is David Paragas, and I'm counsel to Duke Energy of Ohio. As a public utility, Duke is legally required under 4905.22 to furnish necessary and adequate natural gas to its more than 400,000 customers in southwestern Ohio. In order to ensure reliability, Duke must maintain its infrastructure by retiring certain assets and upgrading others. The Central Corridor Pipeline will enhance service efficiency and reliability for its customers. Importantly, the pipeline is designed with safety as its top priority, and the route selection process and ultimate design will minimize environmental impact to the local communities.
Mr. Progress, is enhancement the same as need?
Your Honor, need is an important criteria under this statute. Under 4906.10A, we must demonstrate that there is a demonstrated need for the Central Corridor pipeline. I like the language that Mr. Beeler used, that the need is equated to reliability and safety. In this particular instance, Duke was able to establish need that the Central Corridor pipeline will improve reliability by addressing Duke's infrastructure challenges. The pipeline will allow Duke to replace the propane gas peaking facilities and related caverns, which are now 60 years old and cannot be repaired, replaced, or upgraded. It will also allow Duke to rebalance distribution of natural gas from the south to the north, thereby reducing reliance on a single gate station on peak demand days during winter months. If the propane gas facility fails or the gate station cannot meet demand on the most dangerously cold winter days, as many as 50,000 customers could be without natural gas for heating and cooking. I know the question was asked is, and appellant's counsel suggested that the need must be the public need. Well, in this instance, the public need and Duke's need to provide reliable service are aligned. And so the public need criteria was met under 4906.10A. The pipeline.
I'm sorry. Do you agree with the statements of Mr. Pacheco and Mr. Stevenson that at the time of completing the application, Duke did not really fully investigate the alternative route? So that was not part of the complete packet that was before the Power Siting Board.
Your Honor, the Duke did not complete an investigation to the level at which it completed the investigation for the preferred route. However, upon submitting its application for both routes, it was sufficiently complete for the board to commence its investigation. If I may discuss what occurred in the development of the additional route. The board considered the environmental impact of the pipeline by conducting a route analysis. The methodology that they deployed commenced with starting with 75,000 different routes.
I'm sorry, I don't mean to interrupt, but could you put this in order? So when you say that the board made that decision and looking at it, was that really just based on the first packet? And then they started an investigation looking at all these routes, and then they drove it to the alternative route. So put it in context of order and chronological order for me when you tell me what happened, please.
Yes, thank you, Your Honor, for that clarification. The route selection process, which the board determined to be reasonable, occurred prior to submission of the original application. The original application was amended to address community concerns, but the board needed to make a determination on whether the route selection process was reasonable, which it did. Taking those 75,000 different route configurations and applying 25 different siting criteria was essential because they needed to take into consideration land use, ecological, economic, cultural, and engineering factors. They did that in such to determine whether the preferred route or the alternate route was preferable. Ultimately, the board determined the alternate route was preferable because it is 1 mile shorter in length. It costs $16.5 million less to build. It reduces disruption during construction. It impacts 252 fewer properties and 967 fewer residents within 1,000 feet. And it had fewer impacts to wildlife, streams, and wetlands. And also, it took advantage of the existing Norwood station rather than creating a new one. The one thing that I would like to address before my time expires is that there has been discussion about not taking into consideration the comprehensive plan at Blue Ash. That our route selection process was completed in March at approximately the same time that Blue Ash completed its comprehensive plan. What Blue Ash has failed to demonstrate is how the updated plan was materially affected, how they were prejudiced by not consideration. More importantly, by the time the second adjudicatory hearing occurred, Blue Ash had almost 2 years to demonstrate that there was harm. And of course, they were unable to. For those reasons, I would argue that the appellants have not met the burden of demonstrating that the board's decision is unreasonable or unlawful, and nor have they demonstrated that the board's order is contrary to the manifest weight of the evidence. According to the board's order must be affirmed.
I just want to make sure that I understand what you told me about how the transaction occurred. They looked at 75 different routes. They narrowed it down to a preferred and an alternate. When Duke originally did the investigation, the preferred route was fully developed in the record. It then goes to the Power Siting Board. They begin an investigation, and somewhere along the lines in their investigation, they start looking at the alternative route, and their view is the better route. They take that back to Duke. Duke then does a full examination of the alternative route. But according to other counsel, some things weren't included because there was no conversation between Duke and their entities. Would you agree with that?
No, Your Honor, I would disagree with that process. Duke had multiple public meetings. They had 4 public meetings. They had a symposium with Hamilton County commissioners and public officials, literally hundreds of meetings with public officials, and not to mention the process by which the board follows to grant or deny an application for necessity. So the appellants had ample opportunity to participate in the process. And even as recently as January 21st of this year, additional modifications were approved by the board in an order that was referenced in our brief at page 36. So I would disagree with that characterization, Your Honor.
Would you agree with my statement of how the transaction how the transaction occurred, looking at those sites first, development of the report, preferred really being looked at, alternative not until the Power Siting Board's investigator really focuses on the alternative route, that then Duke fully investigates that. Do you agree with that?
Your Honor, Duke Energy in its submission and its subsequent amendments and supplements to its application demonstrated to the satisfaction of the board that it had fully developed and proved that a pipeline was constructible both on the preferred route and the alternate route.
So
due to engagement.
Is that a yes then?
Yes, Your Honor. Yes, Your Honor.
Okay, thank you.
One follow-up question. The conditions that were placed on the approval of the application, are those something that are negotiated and discussed with the technical staff and others, or is it something that the board comes up with on its own?
Your Honor, thank you for that question. The additional conditions that are imposed have to bear some ability to meet those conditions. And so it's partly a negotiation, but in this instance, Duke agreed not only to build the proposed pipeline to the higher transmission pipeline standards as required by the federal guidelines, but to meet additional safeguards to ensure that this pipeline was the safest possible pipeline that could be developed.
And the conditions that deal with the neighborhood, those, I don't think that, it doesn't, from what I'm getting, it doesn't sound like the neighborhood gets brought into the discussion about that. That's something either the board comes up with or they run it by Duke. How does that work?
Yes, Your Honor. Throughout the process, Duke Energy engages in conversations with public officials on these issues. And that's normally how the process occurs. And the best example is that we had our public meeting prior to the submission of our application. And originally we had proposed a larger, higher pressurized pipeline, but in response to community concerns, we amended that proposal and reduced its size from 30 inches to 20 inches and a lower pressure pipeline, which reclassified it from a transmission pipeline to a distribution pipeline. So that's the best evidence that, we were throughout the process negotiating, working with local communities.
Thank you.
Thank you. All right. Counsel, you've used your time. You may take a minute.
Thank you, Your Honor. Duke's route selection supervisor, Dr. Nicholas, specifically testified that they would have gone, meaning Duke, would have gone back to the drawing board to consider Summit Park had they known about it. That's at page 304 of the transcript.
Well,
Mr. Hebler,
counsel, does it say that that would have altered their plan?
it said, we might consider how that would impact the route. Question, you would at least consider it. Answer, yes. And
Okay, so I hear might and consider, not a definitive, we would have rerouted.
well, they didn't evaluate it at all, Your Honor, so they never had fully developed information in the first place. That's part of the problem. I mean, fundamentally, you never got to that answer. You never have fully developed information when you don't consider a major regional destination park on the route. And then for counsel to say, well, Blue Ash never informed the Power Siting Board or Duke, that's not Blue Ash's responsibility. And if there was all this public, Justice Bruner, I appreciate your questions. How much involvement did Blue Ash have in these conditions? The answer is none. They were imposed after the fact, after the adjudicatory hearing, as part of the certificate decision. So Blue Ash had no impact in these conditions. But to say that somehow it's fully developed information and to say that it's Blue Ash's responsibility to provide that information actually turns the statutory mandate on its head. One other thing, Chief Justice, if I may, just briefly, because it's been represented that Duke had all these conversations with the interveners beforehand. Page 92 and 93 of the transcript, Mr. Hebler's testimony. I asked, and you are not aware of any conversations in which Duke has informed of any limitations on future construction if the pipeline is constructed on either the preferred or alternate route in Blue Ash, correct? Answer, as I said in my deposition, that there will be a time when we have to sit down. Once we get the route identified, we'll have to have those conversations, and we'll also have to apply for a permit. So that will be in the whole process of this permit. That isn't fully developed information. Blue Ash is not getting the materials necessary to fully vet and challenge the route, and the board doesn't have them either. And Mr. Holderbaum, the staff lead, says of the last 35 staff recommendations, the board has accepted 35 of them. It is time for the Supreme Court to step in and reinvigorate the statutory process required by the General Assembly. Thank you.
Thank you. Thank you, gentlemen. We'll take the matter under advisement and you'll be notified of our decision.
Thank you, Your Honors.
Thank you, Your Honor.
Thank you.
All right, our second case this morning is 2019-1813, State of Ohio versus Nicholas Smith. For the appellant, Ms. Hammersmith.
Chief Justice O'Connor, may it please the court, I would like to reserve 3 minutes for rebuttal. Every juvenile transfer has a recipe. Among other things, the statute requires probable cause on the act charged. Where that ingredient is missing, a charge may not be transferred. Here, the state concedes that the probable cause element of the recipe is missing, but argues that it does not matter. This court should not permit the state to bypass juvenile court decisions regarding bindover and hold that when a juvenile court finds no probable cause on a charge, the juvenile court never transfers and the adult court never acquires jurisdiction on that charge. The transfer statute requires probable cause in relation to the act charge. This is true for both mandatory and discretionary bindovers. Specifically, 2152.12 A and B say that the probable cause requirement is in relation to the act charge. And this court's decisions in
That's not exactly what it says, right? I mean, it says for committing an act that would be a felony, the juvenile may transfer the case. So
2152.12 A and B do say, Your Honor, that there is probable cause to believe the child committed the act charged. So that probable cause requirement is tied to the act charge. And that's in both the
And then the next part of it says that if they find probable cause to the act charge, the court may transfer the case, right? So wouldn't case seem to mean the entire case?
The juvenile court can only transfer a case if the procedures listed in 2152-12A and B are followed. So the package at the end that goes over to the adult court is the case, but the requirements of A and B, the mandatory and discretionary bind-over statute, has to be met. Those are different requirements, but in any event, the probable cause requirement is present in both sections of that statute. So a case can be transferred, but not in the absence. The count without probable cause cannot be included in that case that gets transferred over to the adult court.
So counsel, what you're saying then is that when the reference is to the case is comprised of only acts that for which probable cause was shown on the juvenile level, right?
Yes, Your Honor.
All right. So then it's what you're saying is it's an impossibility for the juvenile to be indicted by the grand jury on any other charges. Is that what you're saying?
No. It's impossible for the juvenile to be indicted on those charges that have met the formula listed out in A and B. So if all the boxes have been checked, if the formula is all there, those charges can be indicted in the adult court. If the parts of the formula are not there, like the probable cause as it was in this case, then those charges or that charge cannot be indicted in the adult court. And the adult court does not have jurisdiction to convict on those charges.
Let me ask you this. Does the state have the opportunity to appeal a decision by the juvenile court judge that no probable cause found?
Yes, Your Honor. That was this court's holding in AJS, that the state has an appeal of right from a no probable cause finding in the juvenile court. And it's important to note that wasn't done here.
Thank you.
But I mean, isn't it's the case, right, that a grand jury can indict on an offense where probable cause wasn't found initially, right? It's not there's nothing res judicata about a finding of no probable cause.
We're not asserting that res judicata is at play here, Your Honor. What we're saying is that the adult court's jurisdiction was never invoked with the lack of the probable cause finding in the juvenile court. To use this metaphor again, parts of the formula to invoke the adult court jurisdiction were missing. And that's why the grand jury and the adult court did not have the jurisdiction over the accounts where no probable cause was found.
Ms. Hammersmith?
Yes.
What happens if the juvenile court judge starts making the findings for discretionary bindover and stops when she gets to one or two counts and doesn't go to the rest of them? Does that have any impact on what can happen in the common pleas court?
Could you rephrase your question, Your Honor?
Let's say there's multiple counts and the juvenile court judge finds probable cause on two counts and says, I'm not going to make any more findings. Does that ever happen?
I have never seen that happen, Your Honor, but what happened here was the juvenile court specifically made probable cause findings on some of the counts and no probable cause findings on the other counts. And because of the no probable cause findings, Nick's case was converted from a mandatory bindover to a discretionary bindover. So there wasn't originally going to be an amenability hearing in this case. And because of those no probable cause findings, there was an amenability hearing held. And obviously, Nick was found to be not amenable on those remaining counts, Your Honor.
The no probable cause was found on gun specifications, correct?
Yes, Your Honor.
Okay, so what was the evidence that supported the factual basis for those gun specifications? Were guns observed by witnesses in this case?
No, Your Honor. The witnesses, both of the victims specifically testified in front of the juvenile court judge at the probable cause hearing and said they did not observe a gun. And 3 officers who investigated this case testified and admitted their body cam video into evidence. And there's a video of Nick getting arrested, and there is no gun found on him. So the juvenile court heard all of that information and made a decision. No, there's no probable cause. That low bar, probable cause, cannot be met.
Right. Probable cause means more likely than not, they did what the charge accuses them of. And a gun specification accuses them, a 3-year accuses them of brandishing a gun. And the 1-year gun specification accuses them of just having a gun. What was the factual basis that existed at that juvenile court hearing that the state was arguing supported probable cause on those gun specifications?
I don't know, Your Honor. And in fact, at the end of the probable cause hearing, the state conceded that there was no gun used in this offense. And in defiance of the finding of the juvenile court, the gun specification, the theft upon which there was no probable cause found, and the 2 counts of failure to comply appeared in the adult court indictment, and Nick was convicted of a gun specification and 1 count of failure to comply, and now is serving 3 years in DRC on those counts.
Was there a request once this case was bound over to review the grand jury testimony to see what was presented in that indictment that supported the factual basis for the 3-year and 1-year gun specification that was ultimately issued by the grand jury?
That is not a part of this record, Your Honor. But Your Honor brings up a good point, which is that the Nick did not have the ability to be at the probable cause or at the grand jury proceedings in the same way that he had the right to be at and have other additional rights at the probable cause hearing, because the probable cause hearing is a hearing that invokes the jurisdiction of the adult court, and this court has held that kids get rights at that hearing because of the critically important nature of taking children out of the juvenile system and into the adult system. Specifically, in Alim, this court held that the probable cause hearing is a fundamentally fair process that measures up to the standard of due process. At probable cause, kids get right to full discovery of evidence. They get the right to Brady material, and they get the right to present their own theory of the case and attack any evidence that supports probable cause. And this is all coming from this court's holding in Wilson, which says that juvenile courts have exclusive and original subject matter jurisdiction over juvenile cases.
Counsel, your client pled to this charge in adult court.
Yes, Your Honor.
Knowing he didn't have a gun, he pled to it.
This court has discussed recently that there's a lot of reasons why a kid might plead to a case other than a factual admission of guilt. Nick was 17 years old when he was facing 50 years in the adult prison, and he's having to make a risk or an assessment about going to trial and the risk of that after he had come over from the adult court, or from the juvenile court rather, seen the evidence presented, saw a juvenile court judge, an elected juvenile court judge, say there's not probable cause for that, and then have to be fighting those charges again in the adult court. So the trial assessment
the indictment had a 3-year and 1-year gun spec, right?
Yes, Your Honor.
At adult court. And as part of the negotiation, the state took off the 3-year, right?
Yes.
And in an offer that he had to plead to the 1-year, right?
Yes, Your Honor.
So his mandatory minimum in that plea negotiation went potentially down from 6 to 4 or something, whatever it is as a result of that, right?
Well, there were several other charges that were dropped as a part of the plea as well.
The significance of these gun specifications is they take the discretion away from the judge, they make it mandatory prison. There's no option for the judge to consider community control. Is that correct?
Yes, Your Honor.
So there's plenty of reason why someone would admit to something, even if there was no factual basis.
Yes, Your Honor. Yep. And then adding in his age, and this court's long history of case law about how children's decision-making process is different than those of adults, that was all going into the calculation there. And as such, the guilty plea does not constitute a waiver of the jurisdictional errors in this case. I see that my time is almost up. If I may briefly conclude, Your Honors, our judicial system was built, or judicial transfer system was built to protect children, especially those children who are disproportionately exposed to harsh adult sentences. As such, this court must hold that when a juvenile court issues a finding of no probable cause, the state does not have the authority to indict and convict on that count. And with that, I would like to reserve the rest of my time for rebuttal.
Thank you. Thank you. Mr. Ochaki?
Thank you. Chief Justice O'Connor, and may it please the court, Cuyahoga County Assistant Prosecuting Attorney Greg Ochaki on behalf of the appellee of the state of Ohio. I will be splitting my time this morning with Mr. Peterson for the Ohio Attorney General's office. He will be taking the last 5 minutes. I would just start by briefly addressing the statistics that were cited in the appellant's and the brief in the appellant's amicus.
Well, counsel, before you get there, were you are aware that in the juvenile court there was a finding of no probable cause for the possession of a firearm?
Correct, Your Honor.
Correct. And yet, and the victim said there was no firearm. The arresting officer said there was no firearm, and at the conclusion of the juvenile hearing, they conceded, the state, there is no firearm.
Well,
right?
At the conclusion of the juvenile hearing, Your Honor, the state conceded that at that point, there was no evidence of a firearm.
Okay, so are you saying subsequently there was evidence developed that this young man possessed a firearm?
I have not reviewed the grand jury transcripts, Your Honor, so I'm not aware of that, if that's the case or not. But I can say that during the process, the discovery is ongoing.
Well, you're aware of the case file, what's in the case file, right? What, after probable cause was found by the grand jury, can you tell me what, by reviewing the police reports, or what was additional evidence developed after the proceeding that would have a factual basis to support probable cause for those gun specifications that these defendants either brandished a gun or at least had a gun on them? What is
I cannot, Your Honor.
Okay.
But I can submit that the issue was presented to the grand jury, and the grand jury found probable cause to believe that Mr. Smith brandished a gun.
But you're not aware of any additional evidence that was developed since the juvenile hearing. Is that correct?
I am not, Your Honor.
And if this case would have gone to a jury and not resulted in a plea bargain, do you know what the trial prosecutor would have argued to the jury that supported proof beyond a reasonable doubt that the gun specifications should be responded with a guilty verdict? Should result in a guilty verdict?
I do not, Your Honor.
So basically,
I do not, Your Honor.
Counsel, basically you're saying you had no evidence of a gun. There's no evidence of a gun
I'm saying
in the file.
I'm saying right? I am not aware of. I'm saying I am not aware of any evidence, Your Honor.
All right. So all right, and let's back it up. Then you looked at the file, right, in preparation for your appellate position here.
I did not look at the police report, Your Honor.
Well, okay. Were there additional police reports from the juvenile court? In addition to,
I did not look at the police report, Your Honor. I did not review the grand jury testimony.
All right. So was there a list of witnesses that would testify to the presence of a gun?
Your Honor, I have not reviewed that information. I don't know if we ever got to the point where there was that was an issue. But as far as what we're here for, the issue here is the role of the grand jury, and can the grand jury return an indictment on a charge if the juvenile court found no probable cause at a preliminary non-adjudicatory proceeding? And the answer to that is yes. The authority is Revised Code 2952.12I. When a case is bound over either on a mandatory transfer or a discretionary transfer, that transfer abates the jurisdiction of the juvenile court with respect to the delinquent acts alleged in the complaint. Additionally, all further proceedings as to the act charged shall be discontinued. And the case is now within the jurisdiction of the court to which it is transferred.
So, excuse me, but probable cause eventually is designed to help us point to the truth. But you don't know what's in the grand jury testimony. You don't know any evidence that says that the truth is any different than what the juvenile court found, at least on the progression toward the truth. So, I mean, the statute's there, but I mean, doesn't the truth matter?
I agree that the truth matters, Your Honor, but I don't know what evidence there was. I can't tell you that I do when I don't. I apologize.
And counsel, but if in this situation, if there was evidence of a gun and the juvenile court judge just disregarded that and found no probable cause, the state has a remedy. They can appeal that decision, and they didn't do it in this case.
If this is a mandatory bind over, Your Honor, I agree. But in this situation, I think if you look at the discussion under AJS on when the state has a right to appeal, I don't think we reach on a discretionary bind over whether or not the state has the right to appeal. The reason being is the second prong of AJS says that the order, which this would be the probable cause order, determines the action and prevents a judgment in favor of the appealing party with respect to the provisional remedy. Here, the juvenile court found probable cause that the appellant committed aggravated robbery. He committed a felony. He was over the age of 16. He would not be eligible for a mandatory bind over without the gun, but he would still be eligible for a discretionary bind over, which would be determined at the amenability hearing. So the state still had an opportunity at the amenability hearing to get the case transferred to the general division. And therefore, I don't think this falls, it's different than a mandatory bind over like AJS, where once there was a finding of no probable cause, there is no amenability hearing. You go straight to an adjudicatory hearing before the juvenile court. And I think that's an important difference. I also think we have to look at, under the appellant's theory, what happens to these counts where there was a finding of no probable cause? The juvenile court did not dismiss them. And there was probable cause on counts that were, there was probable cause to transfer the case to the adult court. So what if we follow the appellant's proposition of law and we say that those counts don't transfer up to the adult court, what happens to those counts? Are there parallel proceedings in the juvenile court and in the adult court? The finding of no probable cause it's not, it's a preliminary hearing. The court could still go forward with an adjudicatory hearing. And as I stated before, there are discovery is ongoing. As far as one of the counts, there was a count, the court found no probable cause as far as the theft of credit card services. That could be easily remedied by asking the victim what she had in her purse.
Counsel, I might agree with that proposition that you're arguing that if in the case you presented no probable cause on the gun specifications, but then later discovered some evidence that supported those that wasn't available to you at the juvenile proceeding, and then you presented it to the grand jury, but you're not aware of any of that fact being relevant to this case, right? You're not aware of any.
I am not, Your Honor.
Okay. And
But I think-
presumably they could have just presented the same case to the grand jury, and there was an accusation alleged by the victims in this case that the people had a gun, right?
There was an accusation that one of the two co-defendants said, give me your keys or I'm going to blow your head off.
Right. Okay. So that could have been the only evidence presented to the grand jury that supported the gun specifications being issued by the grand jury, right?
It could have, Your Honor. Policy standpoint here, I think we have to look at the bigger picture as far as what happens in a case such as this, where there's findings of no probable cause on some counts and findings of probable cause on other counts, and the case is transferred. Because what happens to those remaining cases? You could have other victims whose case whose day in court will sit in limbo because the juvenile court has abated jurisdiction, and those counts didn't make it because it was up to the adult court. And I think there's a flaw in appellant's argument also. The situation, what if the trial court had found no probable cause on any of these charges?
You could have
They
appealed.
could have still gone forward with an adjudicatory hearing. There still would have been an opportunity to find evidence. So in one situation where you find probable cause on some counts, the non-probable cause counts just sit in limbo. And in another situation where you find no probable cause on any of the counts, those counts are heard. I just don't understand how this court could sanction that kind of. I think it's a fallacy. It's illogical. I don't see how, and I would ask, my appellant's counsel, what happens in those situations? What happens to these counts? I mean, the juvenile court did not dismiss them.
Counsel, what I find illogical is, if we say probable cause is more likely than not the person is guilty of the crime, and we've asked you, like, what is the evidence that more likely than not they brandished a gun, which both victims said they didn't see, and one was never recovered. Where's the probable cause for the gun specification?
Your Honor, I see we're going into Mr. Peterson's time, but I would just like to say that that's not the standard of probable cause. Probable cause is just more than a mere suspicion. The state just has to produce credible evidence to each element of the charged offense. It doesn't have to provide,
But what's the credible evidence that they brandished a gun in this case?
I can't point to anything, Your Honor, but I can say that that issue was presented to the grand jury, and the grand jury found probable cause.
Okay.
All right. Thank you, Mr.
If there are no further questions, just ask that the court affirm the decision of the 8th District. Thank you.
Mr. Peterson.
Justice O'Connor, and may it please the court. I understand that the court has some questions about the probable cause finding made by the grand jury, but that's not the challenge that Mr. Smith brings, and that's not the legal question before the court. The legal question is not whether this grand jury specifically properly found probable cause for these gun specifications. The court is being asked to write a rule about whether any grand jury can ever indict on charges that where there was no probable cause finding in the juvenile court. And the answer is the grand jury does have that authority, and Mr. Smith's argument is foreclosed both by statutory language and by precedent. And Justice DeWine, you correctly focused on the language of the bind-over statute, which focuses on the transfer of cases, not charges. And that's what this court held in DB. It said that you cannot divide a case into two. You have some charges that remain in juvenile court and some that are bound over and correctly before adult court. And what Mr. Smith really is trying to do is attach some sort of preclusive effect to a juvenile court's probable cause finding. But a probable cause finding in the bind over context is a limited finding for a mere gatekeeping function, and it cuts both ways. The state also cannot take advantage of the fact that a juvenile court found probable cause. When a case is bound over to adult court, that probable cause determination doesn't carry through either way. It still has to go before a grand jury. And this court has made clear that a grand jury may indict on any charge supported by the facts, by the course of conduct. It said so in Adams. Lower courts have followed and applied that reasoning. I'd point to page 8 of the prosecutor's brief where he cites a variety of cases. And I point also to the court to Revised Code 2151.23H, where the General Assembly discussing the authority, discussing the jurisdiction of the adult court, says may be indicted on any charges, even those which were not specifically charged in the juvenile court. And so statute and precedent clearly preclude Mr. Smith's argument, along with this court's decision in Iacona. In Iacona, the court said that a probable cause finding is not a resolution of the merits. So there's no basis to attach any preclusive effect. And finally, I would like to touch on this question of whether you can appeal. No, the state currently as it stands cannot appeal. AJS did not say the state has a right to appeal. In fact, if you look at AJS, it wasn't the no probable cause finding that really was the basis of an appeal. It was the decision not to bind over the case at all. And I would draw the court's attention to a similar situation where you have a probable cause finding or no probable cause finding. That's in the context of a grand jury. If a grand jury returns a no bill, if they decide not to indict, they say there's no probable cause, the answer isn't to appeal. The state can represent to a grand jury and seek a new indictment either under the same evidence or under additional evidence. Well established that there is no res judicata effect. And so, yes, if the court were today to hold that a no probable cause finding would bar reindictment, at a minimum, the court should also say the state can appeal. But that is not the best reading of the statute. It's not a reading compiled by AJS or any of this other court's precedent. Because
Can I ask you a question about that, counsel? Like, in a situation where you presented evidence of probable cause to a grand jury and they issued a no bill, you said you can are you saying you could represent it to that same grand jury, the same case, or you'd have to represent with new evidence, right?
Your Honor, that is a bit of an open question. There are some courts that have held that you have to have some additional new evidence. There are some courts that say, no, you can present the same evidence. But the court need not answer that question here. I'm really just drawing the analogy to how it is handled. And finally, I would point to Mr. Oshaki's point that he was also making, that a no probable cause finding doesn't mean that you can't pursue the case further in juvenile court. And so it's not like this no probable cause finding would forever bar any finding with respect to it. It just means that under Mr. Smith's theory, it couldn't be transferred. I don't think that is consistent with precedent or the statute. I think the 8th District properly applied both and would ask the court to affirm on that basis.
Mr. Peterson, with what you just said, then this concept that the entire case is transferred and the juvenile court would under that scenario lose jurisdiction, how does the juvenile court still proceed on the matters for which it didn't find probable cause? It doesn't square.
I think you're right, Justice Brunner, and that shows why all of the that shows why all the case transfers, because a no probable cause finding isn't a resolution of the merits. And so if it didn't transfer, then it would remain in the juvenile court, but that would be contrary to statute. And so I think what you're pointing to is actually why statute precludes Mr. Smith's argument is once a probable cause finding has been made with respect to some charges, and those charges are bound over, the entire case transfers under Revised Code 2152.12a or b, and jurisdiction is deprived of the juvenile court under subsection I. And I think that your question actually shows why that the General Assembly structured the scheme the way it did.
Except you just said that they could continue with the matters on which they did not find probable cause, the juvenile court could. So which way should we take it?
I guess maybe I misspoke a little bit, and I do apologize. What I meant to say is, if there was no bind over at all, if all of the charges, the juvenile court said no probable cause for any of these charges, we're not going to bind this case over at all, period. The case would still be allowed to go forward in juvenile court. But where you have a split, where you have some cases, where you have some charges, juvenile says, yes, these are probable cause, we're going to bind it over either as a mandatory matter under A or a discretionary matter under B. That shows the case, the whole case goes with it. And so I guess my answer to you about what happens with a no probable cause finding is about if nothing is bound over. If the juvenile court does bind over, it binds over the whole case and everything proceeds in the adult court as long as the grand jury finds probable cause and then it re-indicts the defendant on whatever charges the grand jury finds probable cause for.
So in a hybrid situation, the court could make a finding of no probable cause on some counts and dismiss, and thereafter make the probable cause findings and that might be positive on other counts, and then bind it over to the adult court. At that point in time, the adult court could not deal with the other ones that were dismissed, correct?
I don't think that's correct, Your Honor. I think that would exceed the scope of a probable cause hearing. I think it would be contrary to the court's decision in Iacona, because that would really be a resolution of the merits. And that I think goes back to what I was saying about grand juries. When a grand jury returns a no bill, it doesn't preclude a subsequent grand jury from finding probable cause. And so here, a finding of no probable cause in the juvenile court would, in my analogy, be akin to a no bill, and it wouldn't preclude a subsequent grand jury once the adult court acquires jurisdiction of the case from returning an indictment if the state presents sufficient evidence of probable cause. And I will close and say, whether the court believes that was correctly done here or not, that doesn't go to the legal question that Mr. Smith is arguing. And so I would just encourage the court to affirm the 8th District because it correctly applied precedent and it correctly followed the relevant bind over statutes. If there's no further questions, thank you, Your Honor.
All right. Ms. Hammersmith, you have a little over 2 minutes.
Thank you, Your Honor. I have 3 quick points. First, if the state discovers subsequent evidence after the filing of the initial complaint, they can dismiss the case and refile it. Or if they also have the right to appeal the finding of the no probable cause. Second, this court's holding in DB is wholly inapplicable to this case. First and foremost, because it is factually inapplicable, the juvenile court in the DB case found probable cause on each and every single count that DB was charged with. So the question before this court in that case was not about what the effect of the probable cause finding is. It was about reverse waiver and whether a child gets an amenability hearing or not. And those are 2 completely separate findings, 2 parts of the formula that do not mix. And then third, Your Honors, the Adams case is also factually inapplicable and not applicable to this court's analysis here. In the Adams case, the grand jury added additional counts that were not originally seen in the juvenile court. And here, a juvenile court made a finding, and that finding was ignored in the adult court. And further, Your Honors, I would posit that Adams, which was issued in 1982, is no longer good law with the statutory amendments that have been made since that time, with this court's decision in Wilson, and with this court's decisions in Alim, Iacona, DM, and DM. Unless there are any further questions, Your Honor, we would just ask that this court reverse the Court of Appeals decision. Thank you.
Excuse me, one question. Wasn't Adams also superseded by statute?
Yes, Your Honor, there were statutory amendments that were made subsequent to the Adams decision. that make it no longer applicable to this situation. What it comes down to is that the state has a remedy. If there's no probable cause found, they have a remedy. They can dismiss and refile. They can appeal. Neither one of those things were done here, and they're asking this court to be able to ignore juvenile court orders. And what this really comes down to is, does the probable cause hearing matter? Does the juvenile court's findings regarding probable cause matter? I think with this court's case law about children, it does.
Counsel, do you agree with Mr. Peterson that after a case is bound over, the grand jury indicts again on a felony?
The grand jury did indict in this case, and they do use an indictment as a charging instrument. The grand jury is a way to invoke the jurisdiction of the adult court, but here it's not happening in a vacuum. A court made a finding about this case, and what's important to know is that we don't know what happened in this case is whether the state at the grand jury proceeding told the grand jury that a juvenile court had already made a finding that there was no probable cause in some of the charges in this case. What it really comes down to is there is a formula on each and every single charge. If the formula is not met, that charge cannot appear in the adult court.
But the court made a finding, but you've already told us the finding has no res judicata effect. Doesn't that by definition mean that the grand jury can find probable cause?
We're not talking about res judicata here, Your Honor. We're talking about whether the adult court has
You keep saying you're not talking about res judicata, but you really are, because what you're saying is that juvenile court decision has preclusive effect on the adult court. So whether you call it res judicata or not, that's what you're describing.
Well, we're not arguing either that it has preclusive effect because for two reasons. One, the adult court is not a reviewing court of the juvenile court. The adult court isn't reviewing the decisions. They either have jurisdiction or they don't, and they did not have that here.
Why isn't jurisdiction just determined by the language of the statute that says that the adult court has jurisdiction over the case? I mean, I don't know how you just can avoid that language.
The adult court does not have jurisdiction over the case unless it is given jurisdiction by a proper transfer of the juvenile court. And that's what this court held in Wilson.
So Ms. Hammersmith, you don't really need to go before the grand jury because that bind over is already provided for in statute. Is that correct?
The child could be charged in another way besides a grand jury indictment, Your Honor, yes, in the adult court.
But it would still take some kind of finding of probable cause that they committed the offense to be charged in the adult court, right? The juvenile court finding is not enough for them to be charged in the adult court.
I'm not sure what you're asking, Your Honor.
Well,
they could agree to be charged by information once it's transferred over on the counts.
Yes.
Correct.
Correct.
Yes.
But otherwise, there's got to be a finding of probable cause to be charged in the adult court. They're not automatically charged based on the transfer from the juvenile court. The rules don't provide for that, correct?
Correct, Your Honor. As I've said before, the adult court doesn't get jurisdiction on its own. This isn't a case that just appears out of nowhere. It has to be properly transferred from the juvenile court. That's the system the Ohio legislature created, and that's the system we have to go with. This isn't like an adult case that appears just in the adult court.
So just one last question. How do you deal with 2151.23, which says that the adult court that takes a transferred case can accept a plea of guilty or enter a judgment of conviction for the commission of the offense that was the basis of the transfer, or for the commission of another offense that is different from the offense charge? That's just a mistake that we ought to strike from the statute?
I want to make sure that I'm understanding what you're asking, Your Honor. So you're saying there's an issue with the guilty plea?
I'm saying that revised code 2151.23 states an adult court that takes a transfer case has jurisdiction, including but not limited to jurisdiction to accept the plea of guilty and to enter a judgment of conviction for the commission of the offense was the basis of the transfer for criminal prosecution or for commission of another offense that is different from the offense charged. So once the case gets to adult court, according to 2151.23, the adult court is not even limited to the charges that were brought in the juvenile court, but can convict someone of a completely different charge. So how does that square with your argument that the court only gets jurisdiction over something where the juvenile court has found probable cause? I mean, is 2151.23 a mistake? Should we just ignore it?
What that's referring to, Your Honor, is if a reverse waiver situation, if a child pleads to a lesser offense where they didn't fit in a
That's not what it says. It doesn't say lesser offense. It says another offense, different.
which would be the same thing, Your Honor.
Well,
And
it wouldn't necessarily be a lesser offense. It says another offense different is what it says. So doesn't say a lesser offense. It says a different offense.
the statute also says that the juvenile court has to find probable cause in order to transfer a case. That's what they did here.
So I just want you to help me with what this language for the commission of another offense that is different from the offense charge. So the juvenile court doesn't have to find probable cause for that, clearly under the terms of 2151.23. So
If the entire case, in the absence of certain parts of this formula, can be properly within the adult court, that is a direct file system where the prosecutors and the prosecutors alone get to decide what goes to the adult court. That's not the system that the general assembly.
2151.23 says subsequent to the transfer. So it's a case that's been transferred.
I'm not understanding Your Honor's question. I think we might be misunderstanding each other here.
Well, 2151.23 deals with a case that's been transferred. So, right, the statute says subsequent to the transfer.
Yes.
So that statute allows the adult court to find someone guilty of a different offense that's been transferred by its terms, right? I mean, you can't really disagree with that's what it says.
And that would be in invoking a reverse bind over situation, Your Honor, where the child would go back to the juvenile court and get a hearing.
Where does it say that in the statute?
2152-121.
Says that applies only in a reverse bind over situation. If you go back to juvenile court, I don't read that there. I don't read anywhere in there that says 2151.23 says that.
Point 121, Your Honor. I'm sorry, I didn't speak loud enough.
Okay.
Our argument here today is that the probable cause requirement is a jurisdictional requirement, and if a juvenile court finds no probable cause, then the prosecutors do not have the authority to indict and convict on that charge.
Thank you.
Thank you, Your Honor.
We will take the matter under advisement. You'll be notified of our decision. Marshall, will you call a recess, please?
The court will now adjourn for a brief recess.
Our next case is 2020-368, the State of Ohio versus Earl Jones. For the appellant, Mr. Springman. You'll have to unmute yourself, Mr. Springman.
Thank you, Your Honor. Chief Justice O'Connor, and may it please the court. The test for prior calculation and design under Ohio's aggravated murder statute is not a bright line test. As this court pointed out in State versus Taylor, when it established 3-factor test for prior calculation and design, it is largely factually dependent. And what the state is arguing here today is that the facts in the present case clearly establish sufficient evidence to support prior calculation and design. The state would submit that that issue is not even a close call here.
Counsel, can you tell us the strongest facts that support prior calculation and design in this case?
Yes, Your Honor, I would direct you to the testimony of the most important state witness, and that would be Bryce Kaufman. Bryce Kaufman lives on Overdale Drive where the offense occurred, and he was coming home from work from Advanced Auto Parts when, and he was familiar with Mr. Jones. And Mr. Jones drove by him at a high rate of speed. He was concerned about the rate of speed Mr. Jones was traveling, especially in a residential neighborhood where there were children. So he followed him, but he couldn't keep up with him, and he was traveling at speeds around 45 miles per hour. Well, he gets to Overdale Drive in front of the Prather's house where the offense occurred, and he sees Jones' vehicle parked there. It's parked diagonally, and it's illegally parked. So that's his vantage point of this whole incident, is from the street. So he observed Mr. Jones exit the vehicle from the driver's side. And he walked in front of the vehicle, and Mr. Neary was in the front yard in the grassy area. And Mr. Neary held up his hands, palms up, and there was absolutely nothing in Mr. Neary's hands. There's some evidence that Mr. Neary did take off a shirt. According to Mr. Kaufman, Jones took one step forward, produced a gun from under his shirt. He said kind of from behind to the side or from behind, pointed that gun at Mr. Neary and shot him one time. Mr. Kaufman said that then Mr. Jones took a second step and fired a second round at Mr. Neary. And that one took effect. Kaufman saw Neary's body jerk, and he let out a scream. And then Mr. Neary started to flee towards the garage area of the house. Well, Jones pursued Neary at that point and got off a third shot. And then when Mr. Neary was on the ground, Mr. Jones hovered over him and looked down upon him. Now, Mr. Kaufman didn't hear what was said between the two. And then after that, Mr. Kaufman said he made eye contact with Mr. Jones, and he was a little bit concerned for his safety, obviously. And so he left. He got in his car and he left. Now, I would also point to the court to the testimony of Jamie Ayer. He said that, he just also had a street view of this, not a house view, but from the street. And he said, according to Jamie, when Jones exited the vehicle, he made a casual walk towards Neary. That was supported by Samantha Rice, who she was in the house because she lived in the Prather home at the time. So she had a view from the house, which was a little different. And she described Jones' walk as determined. And I think that all plays into the third factor of the Taylor test, that this murder was not instantaneous or spur of the moment. There had been a long simmering feud that lasted months from December 2015 up until the time of the offense between Jones and Mr. Neary.
So how do we distinguish premeditation from just the intent to kill?
Your Honor, I would, how I did it is I was looking at the legislative history of this, and the General Assembly, according to their notes, they changed the language from premeditation to ensure murders committed with only momentary deliberation or instantaneous premeditation don't qualify. and then recently out of the 8th District. But they also went on and they went further in the notes, and this is important. I should point out that the legislative history says neither the degree of care nor the length of time the offender has to ponder the crime beforehand are critical factors in themselves, but they must amount to more than momentary deliberation. So under our former premeditated statute, you could form premeditation with a momentary deliberation, and they wanted to eliminate that as the worst form of murder in Ohio, aggravated murder. So some of the guidance I think that can help the court was a case that recently was decided by the 8th District that is in direct conflict with this case, to be honest. It's State versus Reyes Figueroa. Hopefully I'm pronouncing that correctly. In there, that was a similar fact pattern. There was a prearranged fight. The defendant and victim meet. The defendant takes one step out of the car and fires a shot at the victim, and also hovers over the victim. And you know, there were a few more shots that were fired in that case, 6 in total, but it's very similar factually. And the court, the 8th District said, prior calculation and design can be found even when the killer quickly conceived and executed the plan to kill within a few minutes. So that's about, you know, that's minutes, not seconds. But here I would submit to the court, we have a plan that was conceived that was more than minutes. I place a lot of emphasis on the fact that not only was this a long running feud, but, you know, in the moments leading up to this murder, Sierra Prather said that it was very unusual and she didn't understand why defendant Jones, I'm sorry, that's my motion detector. But defendant Jones was insistent that she was there, that Sierra was going to be present at her house. And she didn't understand why in the world, he knew the answer to that. You know, they were texting. Jones knew that Sierra Prather was going to be present. And a rational inference that can be drawn from this evidence is that Jones he was so angry and had so much animosity and jealousy towards Ms. Prather that he wanted her to see this murder.
Didn't the Court of Appeals say something about that the plan, the intent was for there to be a fist fight, that he arrived there, they were going to fight, I guess. And then it turned into this shooting instead?
Yes, that's the majority, and quite honestly, I'm perplexed as to how they can draw that inference. I think the inference here is that when you view all the vile text messages that were sent throughout the day between Jones and Neri, and especially the animosity that Jones held against Mr. Neri here, that I believe the inference can be drawn very easily that he planned to murder him. That is in the manner in which this murder was carried out, because they were supposed to, he wanted to make sure not only was Sierra present, but, you know, he's driving his car at a high rate of speed. He opens the door, he keeps the door open, he keeps the engine running. After the shooting is over, Sierra Prather says, well, then he made eye contact with me. Sierra's mother, Catherine Prather, said that, you know, Jones smirked at her. This whole thing, taken in its totality, it's just so abundantly clear that there was prior calculation and design present that I honestly am truly perplexed at how the majority reached this decision on these facts.
Counsel, if we side with you, what would you want the ruling of this court to be in terms of taking these facts and applying them and giving guidance to the lower courts about you know, when facts support a prior calculation and design as opposed to lower form of murder?
Yes, Your Honor, thank you for that question, because I put a lot of thought into it, and I know it's a challenge because you're going to, you know, a syllabus paragraph that I would envision is going to have some kind of facts in it, because the three-factor test that this court established for prior calculation, design, and Taylor, the courts admitted, and it's very accurate, that these are factually dependent cases. And now we have, with the case out of the 8th District, Reyes-Figueroa, which are similar facts, we have a conflict. So what I would ask the court to do is that anytime somebody is engaged, this is a simmering feud, that would have to be an element in there. Jones is armed with a gun, and just because you're armed with a gun, I know what our Court of Appeals said, that doesn't mean you necessarily intend to use it. But first of all, if that's the rule of law, then anybody who carries a gun, whether it's a CCW or they're carrying it illegally, can never be guilty of prior calculation and design. But on these facts, you would want to put some evidence in there that he intended to use the gun because in the manner in which he exited the vehicle, he made sure that he pocketed the firearm. He kept the door open and the engine running. And so I would say that based on these facts, there was a substantial calculation, substantial scheming, substantial planning, and that all are appropriate factors to consider in determining prior calculation design.
So, counsel, is it merely we look at the three Taylor considerations and apply it to the facts here, and then come up with our interpretation or our view of the facts? That's basically because there's no new law that you want us to write, is there?
Well, Your Honor, I analogize this to when the court accepts cases on reasonable suspicion and probable cause. Reasonable suspicion and probable cause determinations are factually dependent. So, for example, if a court takes in a case to determine whether or not weaving within one's own lane of travel amounts to reasonable suspicion, does that amount to reasonable suspicion as a matter of law? That's a case that we need to flush out a little bit. Likewise with probable cause, if you're dealing like yesterday's case, Tidwell, with a tip, what facts do you have that amount to probable cause? And that's the same as the test is here, because in prior decisions, whether it's Palmer, Cotton, Taylor, this court has made clear that we have to look at the totality of the circumstances and deciding whether or not the state met the element of prior calculation design. So I think the analysis, and that's why this case is so important for the court to hear, is so it can give guidance to the appellate courts, and in an area that, one, they need it. We already have a conflict. I mean, this case, it definitely conflicts with the outcome of Reyes-Figueroa. And that's important because now our appellate courts are going to be confused on some of the types of evidence that is needed to support prior calculation design. And I also would maintain this is really an important case because we're talking about aggravated murder, and this is the only offense in Ohio that carries life without parole or the possible death penalty. So it's vitally important to give guidance to the lower courts on what exactly constitutes prior calculation design. It's not easy. It's a challenge, and I think the more cases we have that tell us what kind of facts are needed to support prior calculation design, the more helpful it'll be to the appellate courts. I also
counsel doesn't. Oh, go ahead. I'm sorry.
Don't we also, as a reviewing court, and the First District as a reviewing court, have to view the facts in a light most favorable to the prosecution in this instance?
Yes, and they did not. And that's another important aspect of this case is I, again, am perplexed why the Court of Appeals did not do that. It was a misapplication of the standard of review and for sufficiency of the evidence. Yeah.
So let me interrupt you there. So, for instance, the stopping the car, parked diagonally, leaving the door open, leaving the engine running, the jury was making the interpretation based on the evidence before it. So One person could look at it as, well, he had it left it that way so he could get away because he was planning it, or another could say, oh, in the heat of the moment, he didn't bother to close the door or anything else. But if the jury's making the inference from those facts, the Court of Appeals has to look at that inference through the eyes of the prosecution. And is that a credible, viable conclusion or inference that a jury could make from those facts, correct?
That is correct, Your Honor. And I would also talk about the background of this case. Says a lot, too, about the animosity between the two. And it was very clear that Jones did not like Mr. Neri. That's abundantly clear. And so that plays into it, too.
Right. And when we're talking about sufficiency of the evidence, then essentially, if those inferences could be reasonably drawn, I mean, then it's difficult for the court to overturn what the jury found, correct?
Absolutely. That's why I really am perplexed as to why the majority did overturn this based upon the facts and the strength of this evidence. I really am. I just think it's overwhelming and it's an easy inference to draw. I mean, even if you go further, I know she said, I believe, but Sarah Prather in her testimony said she believed it was all planned, and the defendant Jones was he was determined to get at Neri, and there's plenty of evidence to show that he wanted Neri out of the, or that he wanted Neri out of the picture. He was very angry. You know, there was a feud over. I think part of it was clear. The evidence showed that Jones was very upset that his son was bonding with Neri. I think that was an issue too. That shows some pre-planning and some animosity and anger that ultimately led to this this tragic, horrible murder.
Thank you.
Thank you, Your Honor. I appreciate it.
Mr. Galliard?
Good morning, Your Honors. Chief Justice O'Connor, may it please the court. This will surprise you, but I see the case drastically different from my friend on the other side. The state's evidence in this case simply does not prove the element of prior calculation and design for aggravated murder beyond a reasonable doubt. The Court of Appeals opinion is thorough, well-reasoned, and should be summarily affirmed. Legally, as this court has held in State v. Walker, there must be a clear difference between mere purposeful murder and prior calculation and design aggravated murder. Importantly, there's no direct evidence of prior calculation and design in this case. There's no statement to a witness. There's no written plan. Jackson from the Supreme Court of the United States, Jackson v. Virginia, and State v. Tate from this court both mandate that all the evidence must be considered and only reasonable inferences can be drawn from that evidence. The natural, reasonable interpretation of the state's evidence is that Earl Jones formed the purpose to kill during the split second that he removed the gun from his pocket, and that had there been a plan to kill, he would have gone to the prearranged fight location.
Excuse me, you're arguing about what inference you think should be drawn from the evidence, but that's not really the issue here, right? The issue is whether the inferences the jury drew, whether the jury could sufficiently draw inferences from the evidence, right?
Correct, as long as they're reasonable.
Well, in the totality of the circumstances, why wouldn't, you said the evidence shows that in the minute he pulled his gun and got out is when he decided to kill the victim, but why isn't the other things, that plus the driving up, leaving the car, running, leaving the door opening, how is that not evidence for the jury to find prior calculation and design?
Because it is exclusive of all the evidence. It's looking at those pieces of evidence in a vacuum.
Well, how is it exclusive? Why isn't it part of the totality of the evidence?
It is a part of the totality, but if we're going to draw an inference from that part, it has to be reasonable given the full picture.
Well, look
And when
at
we
the
look
other,
at the full-
look at the other Taylor factors. Aren't they all met?
They are not met. The contentious history is without a doubt met.
Right.
The thought regarding the weapon and the thought regarding the murder location are not met. And when we go into the specifics, there are 6 or 7 factors or facts from this case. And one way to look at this is to juxtapose it against Reyes-Figueroa. In Reyes-Figueroa, the defendant shot almost immediately upon getting out of the car. His leg is still in the car when he shoots. He paused when he shoots and holds and then shoots more. He directed the victim to follow him to an off-work premises location for a fight. And importantly, in Reyes-Figueroa, the victim was shot in the back. The state makes a big point of Kaufman's testimony and tries to say that Mr. Neri was fleeing. He wasn't fleeing. The physical evidence belies that consideration. Mr. Neri, no doubt, used his hands and attempted to protect himself, but he was not shot in the back. He has 4 wounds on his body, to his hand, to his arm, to his torso, both in the front part of his body. He did not turn and flee, and he didn't have time to turn and flee, because as soon as Mr. Jones pulled the gun from his pocket, it's 3 quick succession fires, and he doesn't have time to get turned. Certainly he would have if he had time, but he didn't. And that demonstrates
What happened then that you feel clearly takes us out of the realm of prior calculation and design that makes it, I guess, so spontaneous that the jury could not have reasonably found otherwise?
There are a number of factors. The two of the compelling ones are that Mr. Jones does not fire until Mr. Neri advances, takes his sweatshirt off. Mr. Jones exits the car, pockets the weapon, calmly takes a few steps. Mr. Neri comes off the porch, out of the house, off the porch, down the walkway, down the driveway, at least half the driveway, towards Mr. Jones. At that time, Mr. Jones calmly asks, "Can I get my kid?" It's at that point that he pulls the gun out and fires. If this was a premeditated plan that we could reasonably infer, we would have to have something that supports that he went there with the intent to kill. But when we look at the other factors, there was an established historical pattern of quick exchanges involving the son because of this contentious history. And that is very thorough in the evidence, in the state's evidence. Sierra Prather testifies to it, her mother testifies to it, her sister testifies to it. That explains the parking spot. That explains the door being open. That explains the engine running. We cannot divorce the fact.
But that's, hold on. But isn't that just one possible explanation? That's the explanation you take from the engine running, for example. Why couldn't a jury infer from leaving the engine running that he intended to shoot him? I mean, I don't understand why you think these are the exclusive inferences a jury could draw from these facts when they seem to be facts that could go in all kinds of different directions.
These aren't the exclusive ones, but whatever inferences are made have to be reasonable when looked at in the full pool of the evidence. And what I'm demonstrating here is the full pool of the evidence makes it unreasonable to infer that he had a premeditated plan to kill.
What
motivates like a sufficiency analysis you want us to, or a manifest weight than a sufficiency analysis?
This is sufficiency. It's from Jackson versus Virginia. It's from State v. Tate.
Well,
this is not a credibility determination.
What motivated Mr. Jones to fire the first shot?
His testimony is that he believes he's fearful for his life. He believes Mr. Neri has a gun. The jury didn't believe that.
Right. He didn't see a gun, right? No one saw a gun.
Correct. What motivated?
So then when he fires the first time, if it's believed that he thought Mr. Neri had a gun. He fires on him the first time. There is no gun. What motivates the additional shooting?
Again, these shots come in rapid succession. He removes the gun from his pocket and he shoots at Mr. Neri. The physical evidence demonstrates that. Mr. Neri did not have time to even turn and try to get away from him. We know that because all of the wounds on his body are to the front of his body.
Counsel, according to the appellate facts here, there was a back and forth about how they were going to pick up the child. Jones was going to pick up his son from the place where the child and Mr. Neri lived. Jones agreed and immediately texted Neri to reschedule the previously arranged fight to occur at the same time Jones would be at Prather's house. So he knew he was going to a fist fight. Is that correct? According to Neri agreed to meet Jones at the end of the street. So they had this fight scheduled. So your client brings a gun to a fist fight. I think doesn't that indicate that it took a little bit of, planning to do that?
No, Your Honor. As the state concedes, mere possession of the gun is not enough to establish prior calculation and design. And again, we have to look at all of the factors. And no one testifies that Mr. Jones shoots until Mr. Neri has tracked all the way from the house, down the porch, down the walkway, down the driveway. And no one disputes that Mr. Jones calmly asks, "Can I get my kid?" It is at that time that he fires. To answer Justice Stewart's question, fear, anger, a hyperbolic combination of both, all are instantaneous actions or decisions and motivations. And those are the reasonable.
What, can you clarify for me? I'm not sure. I didn't understand if they were scheduled to fight, and that was a scheduled fight. I didn't quite understand the question of can I get my kid?
They're scheduled to fight 7 houses away. And
so Mr. Jones wanted his child first before the fight?
No, if we look at the evidence, this is what Mr. Jones does. It's his MO. The entire contentious history, they arrange fight locations. Mr. Jones doesn't appear. Mr. Neri does. That is the exact track record. And not balanced, but in looking at all the evidence, the pool of evidence, and knowing that, it's not reasonable to infer that Jones's texts were attempting to locate Neri at that house.
But Mr.
He
Guy,
knew Neri was at that house.
Mr. Guy, you're really going to manifest weight, because if we're going to say it wasn't reasonable for the jury based on this evidence to reach its decision, that's manifest weight. But we're talking about sufficiency of the evidence, whether there was enough evidence to convict him. And I think, I understand what you're saying about the totality of these circumstances, but you started out your argument with it had to get to reasonable doubt. That's manifest weight. That's not sufficiency of the evidence.
No, Justice Brunner. To prove an element, the state has to prove it beyond a reasonable doubt. In reviewing whether the state proved the element of prior calculation and design beyond a reasonable doubt, the reviewing court must look at the evidence, all of it, in the light most favorable to the prosecution, and can only draw reasonable inferences from all the evidence. They can't cherry pick the evidence to block out what does not demonstrate the inference that they want to get to. And that's what the state is doing in its reverse engineering of prior calculation and design.
But it also applies to the first district as well. If its standard of review is to review the evidence in a light most favorable to the prosecution, then with your totality of the evidence, it has to look at everything. And it has to say, if a jury could reach 2 inferences, one favorable to the prosecution, one favorable to the defense, it has to go with the one that's favorable to the prosecution. Am I right?
You are right, but that's not what we have here, and that's not what the Court of Appeals found. We have an inference that the state wants that's not reasonable. And then we have the only reasonable inferences to be pulled from all the evidence, which demonstrate prior calculation and design was not met. Another factor, or two other factors that support this conclusion, is that the son is inside the house. If he planned to murder Neri at that location, he is choosing to shoot directly at his son because the exchange is supposed to occur right then. What he was doing in terms of directing Neri up the street was getting him to a place away from the house because Mr. Neri lived there. Even if we don't believe that, and we can infer that Mr. Jones did know that Neri would be there, or he did plan to have Neri be there, the evidence still demonstrates, when we look at the entire pool of evidence, is that he does not shoot until the gap is seriously closed. And it may be, and undoubtedly, it is a irrational, indescribable decision once the jury doesn't believe self-defense. Nonetheless, it is instantaneous. The full pool of the evidence and the reasonable inferences that we can pull from them leads to that conclusion, which is what the Court of Appeals held. The third Taylor factor is that the shooting must be drawn out, and that is not the case here. The state's arguments to the contrary simply do not align with the record here. The state has never argued that the prior calculation and design element formed in a very short period from the time that he arrived at the house to the steps that Jones takes up to Mr. Neri. Any interpretation of that is forfeited or waived. But even if this court chose to consider those, when we juxtapose this against Reyes-Figueroa and we consider that Mr. Neri was shot very quickly, didn't even have time to turn his body, the only reasonable inference from that evidence is that this was an instantaneous act, an instantaneous decision. One feature of the state's argument that is worth talking about is that the reasonable suspicion and probable cause determination and the development of the area of the law there, that is important for law enforcement. And law enforcement has to clearly be able to anticipate how they can make probable cause determinations. Certainly reviewing courts have to know the parameters of prior calculation and design, but there's no confusion among lower courts on what the test is or how the tests operate. It's just courts viewing the specific facts in front of them and coming to the conclusion that they meet. The state's inability to articulate a precise legal rule for this court to write in this case demonstrates that their appeal here is requesting nothing more than error correction. We ask this court to primarily...
Counsel, thank you. You've used your time. Mr. Springman, you have about a minute left.
All right, thank you, Your Honor. I would just point out that as far as the evidence demonstrating that Jones pursued Mr. Neri, not only came from Mr. Kaufman, who had the street view, it also came from Jamie R. and Jason Yazell. They also saw the pursuit.
Counsel, can you respond to your opposing counsel's last response? Why is this case nothing more than mere error correction? I mean, it seems that reasonable minds could look at this evidence and come to different conclusions. Indeed, the Court of Appeals, the 2 majority and the 1 dissenting judge viewed the evidence and came to the conclusion. How do we take this case and then give guidance to the rest of the courts when they're encountering future murders and say, this separates, this fact in this case separates aggravated murder from mere purposeful murder? How do we rule and provide that guidance?
Your Honor, I would just point out that again, there's no bright line test for prior calculation design, and
Can we form one based on this case?
Well, I think the idea behind the Taylor test is that these are going to be factually dependent, and that's what it gets back to where I'm analogizing this to reasonable suspicion and probable cause determinations, where yes, we have the general rule, we have a test for those, but now we have to flush some of those out on a case-by-case basis. So this court has taken in a number of cases where it's applying the principles of Terry versus Ohio, Draper versus U.S. for probable cause, and New York or Brinegar versus United States. The definitions of probable cause are clear, and now the court needs facts to flush them out. And why that's important is because of the Reyes-Figueroa case is in direct conflict with this. It's just, it's similar. There was a prearranged fight in that case, and there was a shooting from an automobile, and the 8th District reached the opposite conclusion than the 1st District did. And so, and also I would point out that this court also considered in State versus Walker in 2016, also took in another case to explain and give guidance to lower appellate courts that, hey, that was a bar fight, that there was a instantaneous eruption of events. So in that particular fact pattern, as a matter of law, that does not amount to prior calculation and design. So with having said all that, you also have the backdrop is that we are talking about the most serious offense that you can commit in Ohio. You're talking about, it's the only offense you can get, life without parole and the death penalty. So I think that heightens the concern. And I would hope that the court would, want to make sure that we have a series of cases where we can flush out the types of facts that amount to prior calculation and design. And I would say that this, the defendant here, you're talking about, he's forming an intent, in my view, over a very long period of time. It began with his animosity towards Neri. That was present from the beginning, and it just heightened and got worse and culminated in this murder. And along the way, what we have is other issues that are important is we have somebody who, Jones, is carrying a gun in an automobile, and he's always carrying it. Well, just because somebody's carrying a gun in an automobile, that doesn't mean they can't form prior calculation design. And this case is a perfect case to say that, because he had that gun, it was loaded, he intended to use it, he arranged for this fight, he changed the time of the fight to align when he would pick up his child, and then the way he parked his car and the manner he did, it just, those facts just clearly show prior calculation design and would give.
Thank you, Mr. Springman.
Okay, thank you.
Thank you.
All right.
Thank you. Gentlemen, we'll take the matter under advisement. You'll be notified of our decision.
All right, thank you.
Okay, our last, do we have everybody? Yeah. Our last case this morning is 2020-495, the State of Ohio versus Leandre Jordan. For the appellant, Ms. Nelson.
Good morning, Chief Justice O'Connor and Associate Justices. May it please the court. My name is Sarah Nelson, here on behalf of the appellant, Mr. Leandre Jordan, and I would like to reserve 3 minutes for rebuttal, please. We're asking this court to narrow the scope of the felony arrest statute in Ohio by issuing a rule that requires warrants to proceed felony arrests whenever practicable. This rule is necessary because currently under Revised Code 2935.04, law enforcement has no constitutional obligation to obtain an arrest warrant prior to making a felony arrest. The felony arrest statute only requires that police have probable cause and make their arrest in a public place, and allows for the arrestee to be detained until a warrant can be obtained. In this case, Mr. Jordan's arrest was not formalized until after a search warrant was executed. A search warrant that was supported by information obtained as a result from the search incident to his arrest. And notably, that arrest occurred 8 days after the burglary offense, which he was alleged to be involved in, at a time when he was not engaged in any criminal activity, and at a time where he was no longer driving the vehicle that he was suspected to have been driving around the time of the burglary. Despite warrantless search and seizures being unreasonable, or per se unreasonable, an arrest warrant seems to never be required under the felony arrest statute at a time that meaningfully protects the right to be free from unreasonable seizure. Such warrantless arrests are protected in Ohio because they've been deemed generally constitutional, so long as the arrest is supported by probable cause. But constitutionality of a felony arrest should not end at an officer's determination of probable cause, given that the Constitution demands that probable cause be determined by a neutral and detached magistrate. Accordingly, we're asking this court to find that despite probable cause, warrantless felony arrests can still be unconstitutional if police had ample time and opportunity to obtain an arrest warrant prior to the arrest. In Ohio, the Second District Court of Appeals has been willing to scrutinize and invalidate warrantless arrests when there's ample time and opportunity to obtain a warrant prior to making that arrest. And in reaching this decision, it relied on this court's authority in State v. Heston, which set forth a constitutionally appropriate standard for warrantless arrests. It includes a probable cause determination in addition to a finding that it was impracticable under the circumstances to obtain a warrant. Now, the First District declined to follow the Second District's analysis and reliance on Heston because it thought that those decisions were at odds with this court's decision in State v. Brown from 2007, which followed the United States Supreme Court opinion in Watson, which held that probable cause arrests on a felony in a public place are constitutional. But Watson can be read narrowly and should be cabined to cases involving exigent circumstances or contemporaneous arrests. The majority in that case, despite its holding, advised that warrants should be obtained when practicable. It just declined as part of its holding to apply an exigency requirement in every probable cause arrest.
But didn't the court also in Watson go through and state the common law rule and state that with approval? I mean, Watson seems pretty clear that the court thought the common law rule that a police officer could make a warrantless arrest was part of the constitutional requirement. And I mean, it's hard to read that case the way you suggest.
I agree that is what the majority opinion analyzed, and that was their conclusion about the common law. But I would point out that the dissent takes issue with that because it distinguished common law authority to make felony arrests between and felony arrests today, which there are more felonies present today than there were on the common law authority end. So we're giving police substantial more authority to arrest on more charges presently than we did back then. And despite the common law authority in that distinguishing difference, the Watson case, when we say it can be read narrowly, it's because that those factual circumstances in that case included a contemporaneous arrest. And that is something that is factually distinct in our case here. And that's an important point because if police are going to act on probable cause, it should be because there's some urgency present that requires them to forego the warrant requirement. And we don't have any circumstances like that in this case, which renders Mr. Jordan's arrest unreasonable. To the extent that Watson doesn't comport with the rule that we're advocating for today, though, we would ask that this court find that the Ohio Constitution affords more protections to Ohio citizens than the federal Fourth Amendment does, and adopt our rule under Article 1, Section 14 of the Ohio Constitution.
Is there anything in the text, history, tradition of the Ohio Constitution that would support the results you suggest? I don't see much historical analysis in your brief.
Well, I would rely on this court. I would direct this court to its decision in State v. Brown from 2003 when it was willing to depart from the federal standard and afford more protections to Ohio citizens in the context of a minor misdemeanor arrest. And I think that analysis is pertinent to this case as well. Particularly on the interest balancing analysis, we have unfettered police discretion seemingly pursuant to this statute, and that interest substantially outweighs the interest now for the individual to be free from unreasonable seizure. And in order to bring those interests back into balance, we need to narrow the circumstances in which law enforcement is allowed to act on probable cause arrests to protect that crucial right to be free from unreasonable seizure. Also in State v. Brown, this court noted the fact that Montana had reached a similar decision with respect to the minor misdemeanor warrantless arrest issue. And in this case, we have similar out-of-state authority supporting the rule of law that we're advocating for today. In 1994, New Mexico was willing to depart from Watson under its own constitution because it refused to allow the warrantless arrest authority to end at an officer's probable cause determination, because the Constitution does protect against unreasonable seizures, and that unreasonableness is protected by the warrant requirement. So if police are going to have statutory authority to act on probable cause, they also need to show that it was impracticable to obtain a warrant beforehand. The New Mexico Supreme Court specifically asked for exigent circumstances to be present in order for the law enforcement officer to forego the warrant requirement. And the Campos case is really interesting because the officers were acting pursuant to a statute similar to the one in Ohio that allowed probable cause arrests, and they were not hesitant to invalidate that arrest on the basis that there was no exigency. Furthermore, they continued this case and affirmed it as recently as 2015 when they upheld a warrantless arrest when there was sufficient exigent circumstances. And when we read these two New Mexico cases together, they demonstrate how requiring an arrest warrant when it's practicable is absolutely a workable standard. It does not unduly burden law enforcement, but most importantly, it protects citizens under the mandates of the Constitution rather than a statute. Allowing probable cause to end the constitutional analysis jeopardizes the right to be free from unreasonable seizure. It eliminates the vital pre-check on law enforcement authority that the Constitution's warrant requirement provides for. We're assuming by allowing probable cause arrest without judicial scrutiny that the post-arrest check on law enforcement conduct provides a meaningful protection against unreasonable seizures, but we're forgetting that that post-check is often clouded by hindsight bias. In this case, there was no meaningful constitutional protection provided to Mr. Jordan. He was denied his right to have a neutral and detached magistrate determine probable cause because there was no pre-check before his arrest, and there was no meaningful post-check because, as I stated earlier, the next steps in this case were to obtain a search warrant based on the information developed from his post-arrest. Now, based on these facts, it's clear that constitutional restraint on a felony arrest is necessary because otherwise police will be allowed to avoid the warrant requirement and citizens will lose a critical constitutional protection against unreasonable seizure. For these reasons, it's our position that given the constitutional violation in this case, that triggers the exclusionary rule, which should be applied just as it was in this court's decision in State v. Brown. The good faith exception is inapplicable because police did not obtain an arrest warrant in this case. Their conduct cannot be said to be objectively reasonable because the statute itself does have a warrant component to it, but that was completely evaded. Whether it was deliberate evasion or grossly negligent conduct, either way, it was not objectively reasonable to forego a warrant and to obtain a search warrant instead. Respectfully, we would ask this court to find that Mr. Jordan's warrantless arrest was unconstitutional, apply the exclusionary rule to the primary and derivative evidence obtained as a result of his illegal arrest. If there are no further questions, I will reserve the remainder of my time for rebuttal.
Thank you. Mr. Cummings. You'll have to unmute yourself, Mr. Cummings.
I apologize. Good morning again. Chief Justice O'Connor, Justices of the Supreme Court. Your Honors, this is a solution in search of a problem. Peace officers have been permitted to make felony arrest felony arrests in public based on probable cause since before our founding. And this fundamental precept has been, it's survived intact for hundreds of years. It's a bright line test in an era where we don't have very many bright line tests that are viable anymore. Yesterday's Tidwell case, a tipster's reliability is totality of the circumstances. Prior calculation and design is a totality of circumstances analysis. Here we have a bright line test that has served our country well for hundreds of years. It's been embraced by the common law. It's been embraced by the Congress. It's been embraced by most states and their own statutory laws and constitutions. And the appellant has really provided no compelling reason to this court to change what has been a workable, bright line standard for generations. In this case, Mr. Jordan's rights are protected because the law still and will require that his arrest be conducted only if there is probable cause, and that will be tested in the courts. He claims he's prejudiced because the probable cause to arrest him went stale, but that's erroneous. That's a search warrant concept. Probable cause to arrest doesn't go stale. If there's probable cause to believe a person committed a crime today, that probable cause is still going to be there 2 months from now. That's why the law has for so long treated search warrants differently than arrest warrants. You know, the thing sought to be obtained in a search warrant is an item that can be moved, it can be destroyed, it can be whisked away, and that's why there is a time component to search warrants. A man or a woman who there's probable cause to believe has committed a felony, they take that with them. Wherever that person goes, so too does the probable cause to arrest that person. That's why the law has for hundreds of years treated probable cause to arrest in public places.
Counsel, how do you reconcile that with this court's decision in State versus Heston, which said an arrest without a warrant is valid where the arresting officer has probable cause to believe that a felony is committed by the defendant, excuse me, and the circumstances are such as to make it impracticable to secure a warrant?
I don't reconcile it with Heston because I think Heston has been implicitly overruled by this court's rulings in Brown and all subsequent cases after. It hasn't done it outright, but I think the practical effect has been that Heston is no longer good law. It's been discredited and it's no longer applied. And I think that's why we have all courts in this state, all the appellate courts except the second district, apply Brown, embrace Brown, just as this court embraced Watson. And in 1976, when the U.S. Supreme Court released Watson, it wasn't new law. Watson, as Justice DeWine pointed out, the Supreme Court in that case traced the history of how long this concept has been in our jurisprudence, and it dates back to before our founding. Heston's an outlier. The second district cases are outliers.
Well, and Heston, of course, relied on this court's decision in Woodard. So it's not like it was an outlier. I mean, Woodard was decided in 66, said the same thing, and then Heston in 72.
Yeah, and that's correct. And when one reads the cases cited in Woodard, what one finds is that they cite U.S. Supreme case law that goes back many years prior, and yet all those cases deal with search of premises, private premises. You're getting again into the search of curtilage or people's houses. It's a different concept than arresting a person on probable cause that they committed a felony. Heston and Woodland or Woodard's and all those previous cases, they all can be traced back to Supreme Court cases, which were discussing search warrants of premises, private premises. Again, the distinction has been made clear over time, and that's why we have this evolution away from Heston and these types of concepts, because the law has recognized that probable cause to arrest somebody is fundamentally different than probable cause to search. And that's why it's been embraced by not only the common law, but the Congress and most states' constitutions.
Under then what circumstances would law enforcement be required to get a search warrant? They could technically just wait until someone is outside, is somewhere in a public place.
That's correct. That's the law. That's the law in the state of Ohio. There is no boundaries on felony arrests based on probable cause in a public place. There is no limit on that. That's the rule.
Then what purpose does an arrest warrant serve? To be served at a home, to be served in private places?
Well, the warrant itself is not what Fourth Amendment jurisprudence is really all about. The Fourth Amendment is about making sure there's probable cause. It's not about getting a warrant or serving a warrant or getting it and having it one in time, that's not really what it's all about. It's about probable cause. And that's why the case law is developed around that being the focus. It's not about the little piece of paper itself. It's about, did the officers have probable cause or didn't they?
Well, isn't it also about the neutrality of a magistrate listening, or a judge, of listening to the facts as relayed by the affidavit or the officer under oath, and coming up with maybe a more neutral approach to treatment of the defendant?
Well, this court is certainly free to do so. I mean, this court can't, I mean, Watson is going to be precedent, under the Fourth Amendment. If this court wants to find that the Ohio Constitution affords greater protection in this area, it certainly is free to do so. But that would involve overruling Brown, countless cases after that. It would involve rewriting the statute out of existence, because now you're placing an exigency requirement on such arrests where none has existed before. So this court can certainly do that, but as the law is now, it is not constitutionally required.
So how does the language in the Ohio Constitution differ from the U.S. Constitution that would allow us to make that protection greater?
They're essentially the same. The text is essentially the same, and this court has held that the Ohio Constitution is essentially coextensive with the Fourth Amendment to the extent of the protections it affords our citizens. Now, this court has deviated from that, and it has said that, I think, warrantless arrests of minor misdemeanors is not permitted in Ohio, and that is permitted under Fourth Amendment jurisprudence. So in that minor, small area, this court has deviated from the federal jurisprudence. But to deviate in such a major fashion on felony arrests, I think would be a watershed moment, and it would completely disrupt decades, generations of case law and precedent. And I think that to make such a law would not reduce litigation, as the appellant claims. It would be exactly the opposite. If there's now going to be an exigency requirement for public arrests, you can predict what the motion hearings are going to be composed of. Not only is the probable cause going to be challenged, but the timing of it, the exigencies, did they exist? Didn't they exist? In fact, I think you'll see defendants anxious to show there was probable cause early in the case, so that they can then claim that the police were negligent in not getting the warrant right away. So this is just going to multiply tenfold litigation in the courts, and there's really no compelling reason to do so.
Counsel, let me just set it straight. I'm not advocating for this. I asked you the question because you cavalierly characterized a warrant as just a little piece of paper. I think it's a little bit more than that.
Well, I don't mean to be flippant. That's my own paraphrasing of case law that has said that the focus of this analysis is not on the warrant itself and not on the time might be available to get it. The focus is on probable cause. That language is from the U.S. Supreme Court case law in this area. But I apologize. I didn't mean to be flippant about that. But I do think that's an accurate statement when we're trying to understand what the jurisprudence really is protecting for felony arrest warrants in public. It's the probable cause component. And the validity of that concept goes back to before our founding. And I think that it's going to be awfully difficult to change that. And I don't think, if you look at the briefs and you ask what prejudice is the defendant claiming here, it's hard to find where they articulate the prejudice that Jordan suffered here. The closest they come is saying that he was arrested on a stale probable cause. Again, staleness is not an arrest concept. That's a search concept. And more interestingly, I find that later in the brief and in their reply brief, the appellant talks about how delayed arrests don't serve government interests because it doesn't help the victims of the crime. If the police had acted quicker in this case, for instance, Jordan says, hey, you might have caught me with the money in the safe. It delayed the victim's ability to get their money back. I mean, Jordan's actually describing prejudice in terms of how it hurt the victims in this case. That shows you how there's really little prejudice to Jordan himself applying current jurisprudence, because probable cause is still going to have to be established in all of these cases. and it's going to have to be a precondition before he's arrested in public. I notice amicus too gives really no compelling reason to make a change like this, other than to note that it's kind of trendy right now. The Roberts Court seems to be cutting back in certain areas, like protecting the curtilage of your home, the privacy of your house, your cell phone data, GPS tracking of your car, and this type of thing. Until the Roberts Court overrules Watson, I don't think a trendy, hopping on the trendy bandwagon is any reason to change what this court and the nation's highest court has been doing for hundreds of years. If this court has no further questions, I'll just end with, as I said before, I do think that this court certainly can find Ohio provides more protection in a case like this, but the court would have to overrule Brown. It would have to rewrite a statute. It would eliminate a bright line rule that's been working well for generations, and we have so few bright line rules that are workable. I think we ought to hang on to this one, I guess. And I don't think there's any real prejudice to defendants here, because ultimately probable cause is the touchstone of the analysis, and that's going to have to be demonstrated.
Can you recite for me the statute you're referring to?
Sure. It's Revised Code 2935.04. And it's called when any person may arrest. And that's called the felony arrest warrant, shorthand. And that's the statute that allows for felony arrests based on probable cause in public by anybody. And that's basically a codification, again, of the common law concepts, et cetera, et cetera.
So is it your argument that there isn't any temporal analysis with that? So for instance, the felony arrest, if someone, let's say a citizen, saw a suspected crime and then saw that person suspected of doing a crime a month later, the statute allows the citizen to make that arrest as long as it's in public, correct?
Correct. That's the verbiage of the statute, yes.
All right, thank you.
Thank you, Your Honors. I have nothing further unless this court has any further questions.
I would just like to start by recognizing that the Ohio statute in this case does have a warrant requirement. It says that the arrestee can be detained until a warrant can be obtained. So the statute in and of itself does contemplate obtaining a warrant. The big question in this case is, when does that have to be obtained? So if we accept that officers are allowed to make probable cause arrests, are they allowed to further their investigation based on that arrest and not obtain a warrant until they have additional evidence of an unrelated crime that they can now charge multiple crimes for? And I think that definitely runs afoul of what the statute calls for. But in addition to the statute having a warrant requirement,
did you argue anything with the statute below?
No, but it's relevant in this case because of the good faith analysis.
Ms. Nelson, I'm reading 2935.04, and it's when any person may arrest when a felony has been committed or there is reasonable ground to believe that a felony has been committed. Any person without a warrant may arrest another whom he has reasonable cause to believe is guilty of the offense and detain him until a warrant can be obtained. Does that reflect what Mr. Cummings just said?
Well, it reflects his acknowledgement that anybody can make a warrantless arrest under the statute at any time.
But I'm reading the last part of this, and then they have to they detain them until they get a warrant, correct?
Correct. That's exactly what the statute says. So there is a warrant component to this that we're evading based on this sole probable cause determination, because somewhere along the lines, we've just decided, or at least been applying the statute on a probable cause analysis alone. There's no timing component to when that warrant for the probable cause arrest needs to be obtained. And that is crucial, because the question here is, where does the neutral and detached magistrate come into play? Now, it's our position, because probable cause has been construed as a determination made by a neutral and detached magistrate, not a police officer. Police officers' determination should be the exception, and that statute provides the protection by way of presumably having the warrant obtained after the arrest is made, not after further investigation ensues.
I'll stop you right there, because detained until a warrant can be obtained, doesn't that pretty much presuppose exigent circumstances for not obtaining a warrant?
I would agree with that. Like it inherently expects that exigent circumstances be present in order to alleviate themselves of the benefit of the statute. Yes, I would agree with that position wholeheartedly. Again, and then in Heston comes along after, so it's important also to note that the statute in this case was enacted in the 1950s, so pre-Watson. And then Heston comes along and imposes this impracticability component to probable cause arrests, also pre-Watson. So by saying that Watson overruled or discredited these cases, there was authority in Ohio pre-Watson that already provided more protection to Ohio citizens. And through Watson, then we're just sinking the floor back down to the federal level. We should maintain the already greater protections that are existing in Ohio prior to Watson and reinvigorate them in the modern day.
Thank you.
We're not deterring probable cause arrests in this case. We're just limiting the circumstances again to when they should be applied, exigent circumstances, or when circumstances make it where it's impracticable to obtain a warrant. So instances where a suspect is deemed to be a flight risk, or again, contemporaneous criminal activity, those would be circumstances that our proposition of law would allow for, even though this court could go as far as to just say exigent circumstances would be enough. And to the extent that this would create endless litigation, I take issue with that, because it actually would do the opposite. This rule would encourage police to get warrants. Warrants inherently protect police conduct. It promotes good police work. There would be substantially less to litigate from a defense perspective if warrants are obtained prior to the arrest or at a time close to the arrest before further investigation ensues. That's all we're asking for, is to reinvigorate the essential role of the neutral and detached magistrate and apply the pre-check with the warrant requirement before probable cause arrests are made, or at least make sure that it's imposed, the warrant is obtained shortly thereafter the arrest. And because none of this occurred in Mr. Jordan's case, his arrest was unreasonable, illegal, and therefore the information obtained as a result of the illegal arrest should be suppressed. If there are no further questions.
Thank you very much. We'll take the matter under advisement and you'll be notified of our decision. Marshall, will you please adjourn court?
Hear ye, hear ye, hear ye. This open session of the Honorable Supreme Court of Ohio now stands adjourned.